Hey guys, and we are back. Um we've got more people than we had the last time. So we see the prosecutor in the blue jacket, and we see Sherrone Moore at his table with his two attorneys and wife, and some other two people are sitting in the back. So I'm going to put myself on mute, and I guess we're going to get into it. I see you, Jackson. Thanks for coming through. Hopefully we'll learn something about what's been going on today.
You may be seated. Court does call the case of the people of the state of Michigan versus Sherrone Moore.
Good afternoon, Your Honor. Katie Rizzo for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who's state your name.
Sherrone Moore. Thank you.
Christine K. Jacobs on behalf of Sherrone Moore.
All right, thank you. You may be seated. All right. So date and time set for a Frank's hearing, but things have changed. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated. Mr. Simpson.
Your Honor, thank you, and I appreciate the opportunity to address the court. First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional. Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived based on what we now know is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts, counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the context of a domestic relationship, and then an additional count of trespass. Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with, pursuant to our obligation of the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor, one comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship, as this court is aware, but I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove account of domestic violence in this matter, not historically, and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea as a result of that, but I leave that to counsel.
Did you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the original charge.
That would be an entering of a no contest plea to count 4 and count 5 with the dismissal of count 1, 2.
All right, very good.
Thank you.
The court does have before it a plea agreement form that indicates that the defendant will be pleading no contest to the charge of malicious use of a telecommunications device with domestic relationship tag. That is a misdemeanor punishable by up to 6 months incarceration. He will also be pleading no contest to the charge of trespass, which is a 30-day misdemeanor. Upon his successful no contest plea to those charges, counts 1, 2, and 3 will be dismissed. That is the court's full understanding of the agreement. There is, however, one other thing that should be mentioned, and that is with reference to sentencing. The court is going to be given full authority, if the court deems it necessary after a review, to sentence under a deferred program. That is the court's understanding.
That is also correct, Your Honor.
That is correct.
All right, very good. Mr. Moore and counsel, if you could approach the podium, please. Okay, gotcha. And if I may have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the truth, the whole, nothing but the truth, so help you God.
Yes, sir.
What's your name, please?
Sherrone Moore.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. Do you understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about a no contest plea I have to make sure that you understand. First thing is that it first of all means that you're not further desirous or wanting to contest these 2 charges. Do you understand that, sir?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea, counsel.
The basis for the no contest plea is civil liability.
Potential civil liability. All right. very
Yes,
good.
civil litigation.
Got it. Sworn to the charge of. Oh, let's do it this way. To the charge of malicious use of a telecommunications device, how do you plead?
No contest.
To the charge of trespass, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I don't think he has executed any advice and rights form, has he? I think he did, actually. I don't have it.
I believe he did
At arraignment, do you recall that, sir?
Not on the top of my head, sir.
Pardon?
Not on the top of my head.
I have one that I printed up just so we can continue. I did go over the advice of rights form with my client yesterday. So him signing it now is acknowledging that he did review it yesterday.
All right, is that correct, sir?
Yes, sir.
All right, I'll let you. Did you have any questions regarding any of the rights that are contained on that form?
No, sir.
All right. You understand that by pleading no contest, you're waiving or giving up the rights that are contained on that form,
Yes, sir.
particularly the rights that are contained under paragraph 5. You'll see a copy on the podium, which are your trial rights. You understand that you're giving up those.
Yes, sir.
All right. You understand you're giving up your right to appeal.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed thoroughly Pittsfield Township Department of Public Safety report for their case number 25-25629. Counsel, any objection to the court having reviewed that report?
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these two offenses. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit any misconduct as defined in the Michigan court rules, you would first of all not be entitled to withdraw your plea. You understand that?
Yes, sir.
And also, the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any threat, promises, threats, or other inducements which have led to this plea?
There are none.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Cortex.
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. A pre-sentence investigation and report is ordered. Sentencing in this matter will be, will April 13th work for the parties? I have April 13th or April 20th at 11 a.m.
April 13th works for the defense.
Much better. Thank you.
Well, hold on one second. These are Mondays. I don't want Monday. I don't want a Monday.
You want a Wednesday?
I want a Wednesday. Okay. Hang on a second. April 8th, will that work?
I'm not available. I'll be in trial in Oakland County.
The sentencing will go smoothly. No. All right. April 22nd in the afternoon.
That's good for the defense.
Will that work for the people?
Judge, I personally will likely be unavailable in a trial, but it sounds like my office could make certain that it's covered.
Well, you've been here from the beginning. We might as well try to make it work for you too. Give me a special day then. Will April 14th in the afternoon work?
That should work.
I'm checking. April 14th works for the defense.
April 14th, 2026 at
2 p.m.
2 p.m. Before me. Anything else to bond?
Nothing.
Yes, as to bond, we are asking that the bond condition of a GPS tether be removed as a condition of bond for the following reasons. The tether was placed when it was the understanding that the charges my client was facing was a felony and a stalking charge. Now that those charges are dismissed and the narrative of my client being having a history of violence and stalking has now been proven to be false, it's our position that the tether is no longer necessary. There is still in effect a no contact order by my client to the complainant or by any third party to the complainant. He will absolutely abide by that no contact provision, and he has no intent to, by himself or anybody else, to contact the complainant.
All right. Any response from the people?
No, I will say that I am comfortable leaving the matter of the tether in the sound discretion of the court. I will reiterate that our victim's most fervent desire is that the no contact, either direct or through third party order, remain in effect, and that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or a third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as the defendant has been interviewed by probation, and then I will make a decision on that based upon a recommendation from probation. All right,
Thank you for that consideration.
thank you. Anything additional?
No, Your Honor.
Nothing.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
So much.
Court stands adjourned.
Yeah. Oh my God. I mean, who's surprised? I'm kind of, hold on a second. Let me pivot so we can get this visual. I'm a little surprised. Is anybody like surprised? When she came out with I was called away, I had a prosecutorial other obligation emergency, and then I got rear-ended. Oh wait. And then I had, you know what I mean? Like I was on my lawyer-ish earlier, and I'm sorry for all of the delays and blah, blah, blah. I was not expecting them to say, and we worked up a deal. Even though we did talk about that on the tail end of when we were waiting for over an hour. But anyway, long story short, I wanted to hear the evidence too. I really wanted to hear the evidence. I am shocked. We talked about this earlier, that this lady, ma'am, Mrs. Moore, actually showed up again to support her husband. I mean, I don't. Hold on a second,
Elsewhere in
guys.
another county on a special prosecutor case this morning.
I don't blame her because that is her husband. But at the end of the day, my God, the fact that he still has a GPS tether. Hold on. Let me fix this so you guys can see. The fact that this guy has to wear a GPS tether. I mean, I guess it's good in a way because it's just a constant reminder, like you are on a short, you are on my shit list. And I don't know. It would just be, that would be more of a punishment for him than it would be for me. But it would also remind me that this guy was over there at the job site, not to be trusted. He was behind my back betraying me and this family. And he lost his damn job. We've been trashed throughout the whole town. Yeah, I mean, it's just, girl, it's terrible. It's embarrassing. It's so embarrassing. This guy has to wear a damn GPS tether. He's got to go for sentencing next month. He's going to now have a criminal background. He pled no contest, which is still 3 misdemeanors. Are they being hold on. What's he doing? They're dismissing they're dismissing 1, 2, and 3. The felony and the other 2 misdemeanors, and he's guilty. He's no contest to communication device. Hold on, let's hear it one more time.
Will be dismissed.
Hold on. All right, it's resetting. Just give it a minute. So
the result of where we land by adding on the counts is that my best understanding is that
ma'am looks like she has not gotten any sleep right here. She looks very different from how she looked a couple of weeks ago. So it was charges 1, 2, and 3. Stalking, breaking and entering, and I keep forgetting the other one, but there were 3 charges. 1 was a felony, 2 were misdemeanors. They are going to add 2 additional charges, drop 1, 2, and 3, and he was going to plead no contest to charge 4 and 5. And all those people that had to show up, the lawyer who sat up there and put 20 on 10, Miss Shiver's lawyer, who said that there was a history of domestic violence, this, that, and the third. All of these people, they were going to call her lawyer to testify. They were going to call ma'am to testify, Miss Ma'am. They were going to call the police officers. Everybody had to come. And clearly nobody showed up today because I guess they figured out they were going to work it out because he got himself a good lawyer. But the thing is that he's not leaving unscathed. He is going to walk away with 2 misdemeanors. And I guess, that's his lesson learned. He should not have been fraternizing with his employee and having a full-on affair at the job site. That's absolutely ridiculous. It's awful. I hope someone files a complaint with the Bar Association against Paige's attorney. Maybe somebody already has. You never know. I don't know. I mean, it's on record. It's on record that there were some discrepancies between what the actual complaining witness had to say when she was deposed and versus what her lawyer said when she called and made the initial complaint. Also, I'm going to just say this. If they're trying to sue Mr. Moore, which I think we talked about this weeks ago, if they're trying to sue Mr. Moore and her lawyer became, I guess, a witness in a part of this criminal case, like, would that have had an effect on her actually being able to represent her in a civil case? Because they're probably trying to either sue Michigan or sue Mr. Moore. I mean, we don't know how this whole thing is going to go. We just have to wait and see. But I'm not surprised that when it came down to it, that it's time to really talk about what happened, the details, be questioned, all of the things that nobody, that she nor her lawyer really want to do this in criminal court. So anyway, so surprise, surprise, it's been settled. Even SHERRONE Moore took a plea deal. He took a plea deal to the new charges of criminal use of a communication device, some foolishness, and then something else, trespassing. A mess. I still would be pissed. And then the lawyer petitions to get his tether taken off, and the judge says no. I mean, look, this is a major win for him, and him not getting the tether removed, I'm not mad at that. Judge Simpson gave many concessions, and then he's also now gotten a deal. This is pretty much over. So the fact that he has to continue with the tether until he meets with probation, I guess he said once he meets with probation, after that, I guess he'll make a decision whether he can take the cuff off. But eventually it's going to be over. So anyway, he shouldn't have been. I'm just going to go back to don't fool around at work. Okay. Anyway, her attorney became part of the case. Yep. She became part of the case, putting 20 on 10, right? The good old put 20 on 10. So anyway, you guys, thank you for coming back. This was a nice little shorty after they kept us waiting for over an hour. And I still never had lunch. I ended up eating half of a really good apple. So good. But now I'm out of here. Okay, you guys. I think I'm also out of notifications. So if you are catching this upon the replay, make sure to hit the thumbs up for me. If you're new here, subscribe, set your notifications so that you can be notified every time I go live and post a video, because we'd love to have you here every time we go live and or post videos, do premieres, all of the things. So just make sure you come on back. And Bougie Gang, thank you for coming through. Make sure to hit the thumbs up for me, and I'll see you next time, next video, next live. Okay, take care. Bye guys. See you later. Bye. Hope you have a great weekend, y'all. I think we covered everything. Were there any other questions? Did I miss anything? Hey, Rich Auntie. Hey, Boo Boo. How are you? Did I miss anything? Is there any questions? Otherwise, I'm going to let y'all go, right? We're good? We're good. Okay. Make sure to comment down below, and I will see you guys later on. Have a good weekend, guys. Bye.